The funds must be paid to the rightful owner, not the state, once the property is released. So this decision follows an application by 3 parties who are seeking recovery of approximately 50 million pula in accumulated interest. Now, the state has argued that the interest should be paid to the receiver, but Judge Leburu emphasized that owners are entitled to any benefits accrued while their property was under restraint pending civil forfeiture proceedings that happened. So this morning in studio, I am being joined by Seretse Mbeha, who is a legal practitioner from Seretse Mbeha Lawyers, to shed a bit of light in the legal principles behind this this debate of return of interest from accrued from restrained assets. So also just to give us a broader understanding of the implications for future civil forfeiture cases. All right, let me take this time and welcome you for coming through this morning. Very good morning to you.
Good morning. Thank you for having me on your show.
All right, thank you for your time.
Yeah.
So you got to help us understand legal speak.
Yeah, it's my hope at least.
Absolutely.
Yeah.
So just to put us in context, maybe if you just give as a bit of background just on the key facts of this case.
Yeah, the key facts go like this. I think some time back on the occasion of the 13th of December 2017, a restraint order was issued against Bakan Seretse and 2 of his companies on the basis of some funds that he held in his bank accounts at the time, some in his personal account and some in his 2 companies, which were connected, allegedly connected with the famous, or I would say infamous, infamous NPF saga. So a court order was then issued on the basis that they were allegedly proceeds of crime, subject to an application to be made before the High Court for forfeiture of those funds to the state. And indeed, in due course, an application for forfeiture was made before the High Court on the basis that the money in question allegedly belonged to the state. And as fate would have it, that application was dismissed on the spot with costs by the High Court, and obviously being heartbroken by the outcome of that judgment by the High Court, the state took it up with the Apex Court before the Court of Appeal, and the Court of Appeal, similarly just like the court below, dismissed the application by the state with cost, in which case then the state was ordered to discharge, in which case the restraint order that was obtained in 2017 was discharged, and the state was ordered to surrender the funds back to Mr. Seretse, and this was a sum close to a little over 82 million. Right. Yes.
Okay. So, but then this whole time, during the time that these assets were restrained, the accrued interest, then this is where we are now today.
Definitely. So, this is the relevance of this discussion.
Right.
So, during the period of 2017 to 2021, when the Court of Appeal finally made its official stamp of approval on the High Court decision, the funds were kept in an interest-bearing account at Capital Bank. So the million pula legal question in the application that was ultimately brought by Seretse and Co, I mean in Co referring to his companies, is that the state decided to withhold the interest, which was agreed to be in the tune of a little over 50 million. Okay. So the question was, to whom should this interest be payable to? Right. On one hand, Seretse and company felt that since this was a progeny of his 82 million funds held between that period, it must be payable to him, whereas the state on the other side strongly felt that no, the money belonged to the state because it originally came from the NPF fund.
Well, it was alleged to be connected to that scheme.
Yes. So
let's come here then, because this is where part of the public debate is in the case of civil forfeiture. What's the position of the law? Does the law necessitate for such assets to be kept in a manner that this was, in a manner, I mean, in an interest-generating account. Is there an alternative? You know.
Well, in my view, because we would have to locate the answer, or rather perhaps locate your question within the framework of the PICA, which is the Proceeds and Instruments of Crime Act. Yes,
okay.
That in terms of the law and the relevant sections to that effect, there is a requirement that the receiver, in this instance, who is a public officer, or let me just say, generally speaking, the state itself, the government, must preserve the value of the property throughout the legal process up until a determination is made by a court that this property indeed is these are proceeds of crime, and as such they have to be delivered or surrendered to the state.
So preserve the value of the asset. Now that's where the trick is.
And we are talking money. So which must over the course of time either depreciate or appreciate. So in this instance, because it was put in an interest-bearing account, obviously it multiplied in that way. It snowballed, and so the question then was, who should take the interest? Yeah.
All right, and then does the same instrument, the proceeds of crime, then go on to I will say prescribe what then happens to the interest, or what informed this judge this ruling by Justice Leburu?
Well, it doesn't say much. That is why you end up having this application before courts, because it was hazy in terms of the law, as it were, on statute. On the statute book. So the bigger contention by the state was that these funds belong to the state. Alternatively, if it does not belong to the state, then it belongs to the bank. And the court was like, you are approbating and reprobating, you're blowing hot and cold. It cannot belong to the bank in one moment, the next moment it belongs to the government. So the ratio or the legal reasoning of the court was that it would have been a different case altogether if this property was found to be indeed a proceeds of crime. In that event, the interest would belong to the government. But in an instance where the court, the state was unable to prove its case on a balance of probabilities that indeed this money in question does not belong to this person. So in that event, there is no reason why the state, which has no connectivity with
the money,
then claim to have some entitlement to or over this money. So it was pretty much a simple case in my view, except that yes, it involved a whooping amount of money. That is why perhaps there was so much talk about or just around that issue.
Yes, well, even just coming back to the merit of the case remains of public interest.
Yes,
in that. So failing to obtain a conviction, and in a case where there's so much that has transpired back and forth, we're seeing so many precedents with this very case. What is that then saying? Because that is a lot of cost. You know, when you're looking at the protraction of this matter, is it a question of capacity or competence that we failed to, we had a case forward, but then we failed to get a conviction on it? What does that mean? Does this mean that there's capacity lacking to prove the case from the side of the state?
I wouldn't necessarily say it's lack or devoid of capacity, because every single time a litigant goes to court, there are only two possible outcomes: you win or lose. But we cannot merely want to point a finger of blame at you because you lost out. I think that there was so much at stake when these allegations of NPF first began, and it involved because you'd want to recall that at some point we're talking about a figure of 250 million. So 50 million is merely a small fraction of that figure. So I wouldn't blame the DPP and say they dismally failed. I think it was a question of the paucity of evidence. There wasn't enough to prove their allegations, so that's why they ultimately had to fall and fail.
At the beginning of the case, then, because what we understand the Seretse was arguing was that there were means that he could demonstrate that these were not his assets were not acquired through those funds. So then what one wonders is, was that not taken into account at the beginning? I mean, if he says, no, I can show you where it is I get the money for these assets. But then we go on and have this protracted case as well.
Yeah, well, that we can ask the state. We don't know why. I can only second guess, but I can't really say it with a measure of exactitude why that was the case.
Yeah.
But in all fairness, it looks like there was no case from the very get-go. And I just touched base with one of the lawyers who was representing Seretse and Co. He said, well, I'm not quite sure. It looks like maybe the state might also want to appeal. So perhaps they still feel there's a strong case, even when the Court of Appeal dismissed their initial application for forfeiture. So in my view, it must be the end of the road.
Okay, because when it comes to law, when something like this happens, in layperson terms, it sets a precedence, you know,
yes,
that can be applied in future cases. I want you to speak to this, or have there been other precedents in similar, you know, instances to this?
Yeah, a precedent in law, it means that there are other similarly decided cases in the past, and if there is going to arise a similar case in the future, the expectation is that it must have a similar outcome. So what becomes of import or importance there is the legal reasoning in those cases, not necessarily the outcome, but the ratio behind it, the answering of the judges and their justification for the outcomes that they make. I cannot say that there has been a similar case like this one before, but what I can speak to is that yes, indeed, there is precedent to the effect that if the ratio, or say the legal reasoning, is such that if property that is held under a restraint order, which is not declared to belong to the state, is then discharged or lifted up. Even without the law, common sense dictates that it must go back to the legitimate holder or to the lawful owner. Right. So that is just how it works.
Question of whose money is it in the first place?
Yes, yes.
Let's come back to here. I think I'll take it back to the criminal, how do you say, criminal procedures and
evidence.
And evidence. Please just pronounce the correct nomenclature. Criminal
proceedings. Yeah, they are civil proceedings on one hand. Yeah. They are also, on the other hand, criminal proceedings.
Right. I'm talking about that legal instrument that.
The proceeds. The proceeds and instruments of crime act.
Right.
Yes.
The proceeds and instruments of crime act.
You can just say PICA.
Right. Would this not perhaps, for lack of a better word, simplify issues if it was more pronounced or around then what happens on issues of interest and stuff like that? Should it perhaps in the future not be pronounced somewhere?
It should probably, because...
And not be left to reasoning and yeah.
Why the state was laboring under a disillusion that the interest belongs to them was on the strength of some section in the PICA, section 68, where they argued that this is money held in a confiscated trust fund. And the court was able to distinguish that from the funds under a restraint order to say these were not collected in the first place. They were not confiscated, because this is not similar to when property has ultimately been forfeited and held as such in that account. So
it was still before the courts, so it cannot be,
Yeah, definitely. So I would say, yeah, maybe there's need for our parliament to do a better job in future going forward.
Right, yeah. to be clear around that. Because the public debate is quite rife.
Definitely.
Right.
There's an uproar. Yeah. Remember that the NPF saga, ruffled feathers almost in every section and corner of the society. And when people wake up to such headlines like this guy's walking away with 50 million, obviously they feel like they have been...
it's our money.
Definitely it's their money. So, yeah, it needs to be handled better.
I would say. So then when it comes to the issues of... I'll go back to the one about civil forfeiture. Do the proceedings or procedures were procedures followed to the T, you know, in arriving at actually even seizing the property in the first place?
Yes, the procedure was done accordingly in terms
Okay.
of the law from the start. That's why they went to court, because you cannot merely see someone's property, like money in this instance, without getting or at least securing a court order. They did secure that. That was fine.
Right.
Now, the most critical part was whether they will win the forfeiture application. Yeah.
Okay. I want to come to your view on just perhaps how this might impact or influence public confidence.
Public confidence in our courts.
Right.
Yeah, it's a wishy-washy thing.
Okay.
Public confidence in one moment, you know, there were so many moving parts, and a lot has been taking place in Botswana. I think for the longest, there was a narrative that the public has lost confidence in the judiciary, particularly in cases of national importance. But there were yet other cases where, you know, litigants would make a score against the government, and you'd hear others saying, yeah, now we trust our judiciary is back on track, is on course. So for me as a legal practitioner, I'm not here to batter the judiciary. I honestly believe as an officer of the court that our judiciary is still up intact, is still impartial and independent, except that when you lose as a litigant, or sometimes as a legal practitioner representing one of the litigants, you also become you take your emotions into it, and your judgment, you know, goes off the window, and you are not in a position to be objective about it and accept the outcome, that it's a democratic process where two possibilities can happen. You can be confirmed or be dismissed. So I still believe that our judiciary in Botswana is very independent and impartial. Of course, we have seen few instances where you might highly suspect that no, things went down south. They didn't go according to at least normal expectation.
Okay.
Yes.
And then public prosecution?
Public prosecution.
Yeah. Because that's another area where public has shown interest, is that over technicalities, some for lack of a better word, some people get off scot-free. You know, public confidence on the public prosecution.
Yes, our public prosecution, at least of late, there has been a lot of the public confidence has been waning. To start with, because there is even there's a court judgment by the same judge in this matter, Justice Leburu, where he said that it's no longer prosecution but persecution. You understand? So it has attracted or gotten that stain on itself, and we can only hope that it will do things much better going forward. But I still believe in the men and women, at least the technocrats, because it also has to do with the guys at the very top of the DPP who make the decisions and then drop a file on your desk. Yeah,
because some people have said our prosecutors are rushed into these cases without having been given enough time, perhaps, you know, to satisfy themselves with the body of evidence.
They have no say.
It's
for the director to make a determination, and if they feel they could be a political influence in it, you as a technocrat do not have any influence, no power to say, well, I can take this up or not. So you have to.
All right. Well, thank you for sharing your view, Mr. Mbeha.
My pleasure.
All right. Sharing the views there of Re Otuste Mbeha, at least helping us get a grasp of the legal speak and the legal facts and positions around this recent ruling by Justice Leburu that the 50 million belongs to the owner of the funds in the first place.
We are losing people that we know in circumstances under which we should not be losing them. We have made progress.